Welcome, everybody. This is Rob with Procore CPA. Many of you have likely been on our webinars in the past, and we're glad to have you back here again today. This webinar that we've got put on today is entitled 2013 Employment Law Update, 5 Policy Landmines You Need to Be Aware of. As you know, if you've been following Procore CPA for a while, Procore is a firm that works specifically with dentists and takes a very proactive approach with tax strategy, accounting information, and your practice data to put you in the best possible financial position. We've had a series of webinars that have been going for quite a while, and many dentists have been participating. Likely you yourself have participated and seen some of our other webinars. And really our objective in doing this is to be able to bring valuable information to you, the dentist, on subjects that you care about. And so thank you to many of you for suggestions on those subjects, and any additional suggestions or ideas that you have for future webinars or things that you'd like to know about or better understand. We love that kind of feedback, so keep that coming. Oftentimes, as a CPA firm and in working with our clients, we get questions related to HR issues. We tend to be a trusted advisor, and so regularly we're getting questions about how do I handle this situation, or what do I do here, or how should we be paying our people? And while many times we have answers to those questions from a tax perspective or a strategic perspective, we need to a lot of times go back and do research from the legal perspective. And so we thought it would be great to invite an expert on employment law and be able to bring you some real valuable information related to HR issues and employment law. And so we invited our friend Paul Edwards. He's from Cedar HR Solutions. He's an expert in this area. And Paul, we'll turn the time over to you to bring us some great information here tonight.
Rob, thanks. I really do appreciate the opportunity to speak with everyone. Just a little bit, you know, I mean, it's more and more we are getting contact from folks like you, CPA firms that are out there. You're in the trenches with your clients, and we know that, like you said, they have questions about employment issues. I think things have really changed over the last 4 or 5 years because HR issues have become, I guess, a little more difficult to solve, a little more critical. They can, like you said, you were talking about putting everybody in a better financial position. You know, lawsuits around employment issues are very common now, and just to defend a lawsuit, it can cost you $30,000 to $40,000, and that's just to get started. So there's no winning in that, and our goal as an HR company is to actually keep our members and our clients away from attorneys, and so that they don't need to hire an attorney and end up in court somewhere in a big fight. So we really appreciate the relationships and the connect through to your members and being able to talk to them a little bit today. And I did want to give a little bit of background. I think I need to get a new picture for these presentations. I look kind of grumpy there, Rob. Cedar was formed for dentists. We put together Cedar back in 2006. We are a sister company to one of the nation's largest asset protection law firms, and they were getting the same thing you guys are getting. They were getting questions about employees. Of our 800 members across all 50 states, I would say 90% of them are dental offices. We create customized employee handbooks for them, and then we have a support system so that when they have an issue, they can get on the phone, speak with experts, and we actually do a lot of the work for them. And because everybody's in a different state, the rules really vary from area to area, and so it's important that when you're talking to someone, they understand what the rules are and the laws are in your area. And so that's what Cedar does. And we're manned by attorneys who are our advisors. Cedar Solutions is not a law firm. We're an HR company. And our advisors can be quite helpful in problem solving and in issues of HR. So, Rob, I'm just going to jump in if you don't mind.
Sounds good. Thanks, Paul. And again, we're excited to hear this information and have you as an expert to be able to convey these things, these ideas.
Well, let's talk about the landmines. I'm going to concentrate on 5 areas where we see issues come up often. Overbroad confidentiality policies in the National Labor Relations Board. I'll talk a little bit about wage and hour violations. I want to discuss documentation, especially in the context of corrective action notices and policies. Everyone has heard of at-will. I'm going to try and remove some of the myths around that and also emphasize the protection that's available to you through your at-will status, basically what it is and isn't. And then I'd like to kind of wrap things up when we'll talk about some of the missing policies and protections. A lot of these have to do with embezzlement, and again, that leads back to keeping your guys in a better financial position. Overbroad confidentiality policies in the National Labor Relations Board. The National Labor Relations Board was really not a factor in small businesses. And when I say a small business, I mean typically it's a dental practice with, less than 50 employees. You would not see the National Labor Relations Board show up in your business because their job is to enforce the National Labor Relations Act, which is typically associated with unionization activity. And so up to about 1.5 years ago, it would be rare that anybody that we work with would have to worry about these guys. And then all of a sudden they were funded and given a mandate. And what we've seen them doing is actually through continuing education, they're letting attorneys know around the country that they are very interested in investigating circumstances where their rules are being violated, and they want to do this whether or not unionization is taking place. So a lot of small businesses, and we know of at least one dental practice, have found themselves embroiled in a battle with the National Labor Relations Board, even though they only have 15 employees, and they had nothing, they had no unionization going on. I want to talk about some of the policies that a lot of you are going to have in your handbooks. I know that you'll have at least one of these, and I want to let you know that these are extremely problematic and that it's something that you're going to want to take care of. The first one is very common: no discussing wages or salaries, or some form of that, or some discouraging of it. What you should know is that this policy is illegal. It violates the National Labor Relations Act, which says that you may not do anything that would tend to chill the employee's ability or right to discuss their benefits, their wages, or their working conditions. It also violates the Lilly Ledbetter Act. President Obama signed that into Congress, and Congress passed this act. They were all behind it. It's called the Lilly Ledbetter Act. It was about pay discrimination. And so if employees are forbidden from discussing their wages, then that would mean that they would not be able to discover that they're being discriminated against. And then finally, the EEOC has made it very clear that if you're carrying any kind of policy like this and someone files a complaint against you around wage discrimination, that they would consider this to kind of be the nail in your coffin, and they would go ahead and issue a right to sue letter with very little precursory investigation. So if you have this policy, you really do have a ticking time bomb, and it's something that you definitely don't ever want to fire an employee over, and you want to get it out of your employee handbook as soon as possible. And I'll try to remember to discuss, what do you do when you have some of these policies in place, and how do you correct that? What do you have to do to get those set aside? Another one is no disparaging remarks about the practice, the doctor, or other employees on Facebook or elsewhere. Both of these policies, I can see why you want them. They are things that you don't want to occur. You don't want your employees arguing over their wages and salaries, and you don't want people saying bad things about your business, particularly not about the doctor and certainly not about each other, but you cannot control their activity on Facebook or elsewhere. That isn't to say that they can't say that you can't forbid them or take action around them saying anything on Facebook. In other words, they can't get on Facebook and say that the doctor, is doing something that he's not doing. That's not okay. They can't make false remarks, but in a very real way, they may be well, what am I looking for? It's concerted activities. So they may be participating in concerted activities. So they may say that, look, we're working long hours, we're not getting breaks, and I'm not even sure that I'm getting paid for every hour that I work. You know, working for Dr. X is tough, and someone else chimes in, and the next thing you know, you have concerted activity. So having the policy in place can be problematic. Coupling it with taking some kind of adverse action against an employee for making those remarks, which we see all of the time, is extremely problematic. And before you do it, you really want to talk to someone like us and make sure that you understand the rules around this before you start trying to enforce something on it. And then the final thing is to just imply everything about the practice is confidential. I'll bet that if you have a handbook and you look in it, you'll find some form of this. We had this, and once we started to hear from the National Labor Relations Board and they finally started issuing opinions, we had to go back and change our handbook for all of our members, which is something I want to bring to everyone's attention. Employee handbooks really now are a living, breathing document. It may be one of the most important documents that you have in your practice, and there's no way to do one and leave it set. Like, okay, we got done with that, and now we're done with that, and there's nothing else to worry about. Handbooks are going to need to be updated periodically, sometimes yearly. It's possible for us to issue a handbook and for there to be some kind of major change in federal or state law, and for us to have to go back and make the change the day after that we've issued the handbook. So very important that you stay up to date. And this is one of those areas where implying everything about the practice is confidential is kind of a catch-all. If I just say everything is confidential and then someone breaks what I think is confidential, I could use my at-will status. Really don't have to give them a reason, but if I did, I'd just say you broke confidentiality and I'm letting you go. And this is another area where the NLRB is red flagging this policy, and they'll come in and can take enforcement action. And so we want to make sure that you don't have anything in there that would help them to gain ground against you, especially, and really everyone, this stuff comes up when you're in upset with someone. You're growing your practice, you're up to something, you have an employee that was great, and all of a sudden they're not, or maybe you didn't do a great job hiring them in the first place or vetting them, and now you've got someone in your practice, and you know you need to get them out, and you know that they're contentious, and you let them go, and they begin to Google, and they contact the Department of Labor because they can do it online now. They may even get to talk to an attorney online, and they're looking to see if their rights have been violated. And an attorney says, well, do they have a policy that tells you that everything's confidential? And the employee answers yes, and the next thing you know, you're embroiled in an issue that you never thought was going to come back and bite you. So you want to make sure that, again, that you don't have something like this policy in your employee handbook.
Now, Paul, I have a couple quick questions for you
Sure.
on there. I mean, seeing how confidentiality can be such an important aspect, do you have a couple quick tips about some things that they can still protect themselves but make sure they're not getting into trouble? And then following that, along with confidentiality, a confidentiality clause. A lot of times, dentists have questions or concerns where they bring in an associate regarding non-compete. Is that something that you can give us a few ideas on as well?
Sure. We can talk a little bit about associate agreements as well. So, look, you have an interest in a legitimate concern of protecting your, first of all, your patient information, your PHI, and HIPAA, and you should have a HIPAA statement in there, and it can be very strong and very broad. And I don't think I have to go very deep into that, but you understand that doesn't upset the National Labor Relations Board because it's very focused on that issue. And then the second thing is your business interest. That is, what do you charge for fees? Your client list, your advertising, and I could go down a long list of things that actually belong to you that you have a business interest in protecting. And it's okay to have very, very strong confidentiality policies. And in fact, if you work with someone like us, we actually have a separate confidentiality agreement that goes into place with all the employees, which actually gives you a little more power and a little more teeth when an employee leaves and breaks confidentiality. It can serve you very well if it's in place and it's written properly. With regards to associate agreements and non-competes and your interest in protecting your business in that way, this is something that we're actually quite well known for. Our associate agreement, we may have done more of these than any other business in the United States because we actually focused on it early on, and I have done hundreds of these because of the nature of who we are and what we do. And if you're in a state, you're listening where non-competes are available, that's definitely something that you can put in place. You can have a non-compete in place, you can have non-solicitation of your patients, you can have non-solicitation of your employees, and if it's available to you and it's written in a reasonable way, that's absolutely something that you want to have in your agreements. And I know you guys have a broad reach. For those listening in California, you're actually now required by law to have a written agreement when there are commission structures and bonuses in place with any of your employees. So that's another area where we could go off on that tangent. So yes, you can protect confidentiality in all those areas. You just have to be careful about getting out there and making it so broad that it upsets the NLRB and it gives a labor attorney teeth. And I can tell you what happens is you end up with depositions, your practice open but closed. Open meaning that you have to pay your employees while the NLRB depositions them at the local Holiday Inn. You lose production while your business is closed for those days. It's just terrible. We see them go after small car dealerships. We've seen them in a lot of areas. So I really am not one to strike the bell of fear on this. We were kind of stunned to see the action. And if you Google this and you check into this, there's a lot of controversy around the National Labor Relations Board. And even though the board is in trouble right now in a couple of courts, their adjudicators are still out there, and they are still pulling people in and making their lives miserable. I want to talk.
From the confidentiality standpoint, just so I'm understanding, if you have a legitimate business interest, you can protect that. You need to define that business interest, as some type. This is your intellectual property, and then you can protect yourself in those areas and just make sure it's not too broad. And I've seen the same thing as it relates to non-compete agreements as well. You want to make sure that you're protected, but having it be trying to have it be all-inclusive and too broad and too encompassing can actually invalidate it. So I'm really a strong believer that you need some professional advice and you need some opinion regarding your particular situation, especially relating to these subjects.
Yeah, and there are some subtle nuances. For instance, in Louisiana, you can't use a radius. You have to name the parishes. In Texas, you have to give a buyout provision. In Colorado, they weren't allowing non-competes up till a short while ago. But you can't use any kind of a standard non-compete. They have a little trick you have to pull. Well, that's not a way to put it. It just has to be stated in a different way. California doesn't allow them. Other states don't look on them favorably, and so you just need to know, what your position is when you put one of these in place. And so that is something we can help you with. But again, in California, what we do is we make sure that the solicitation and the confidentiality are extremely strong. You avail of what's available to you, and make it as strong as you can. There was a story not long ago in the news. You guys probably, even if I bring it up, you'll remember. Applebee's fired an employee. A pastor was visiting Applebee's, and she wrote on a receipt. She wrote on a receipt, I tithe or I tip God 10%. Why would I tip you? And the employee then, and I think rightfully so, answered her question by putting it up on a website. I think it was Reddit or something like that, posted it, and for everybody to see, and responded to her, do you understand I make $2.06 an hour and that I live off my tips? Applebee's fired her for doing that, for breaking the policy that you see in front of you. The employee, Applebee's, actually was in their rights to terminate her for doing that because the person's name was actually on the receipt, and I think for other reasons. But if you look at Applebee's policy, there's some problems in this policy. It says about or displaying internal Applebee's happenings that might be considered to be a breach of privacy or confidentiality. Well, a breach of privacy, I don't know what that means. Does that mean that if they see an OSHA violation, that's private and confidential and it has to be reported to a supervisor before it can be told to anyone else? And so I thought it was interesting that Applebee's threw this up on their website saying, hey, they violated this policy, which she did, but it contains a ticking time bomb right in the middle of the policy. So, you know, it's easy to slip up. I want to move on to wage and hour violations. Some typical areas where we see problematic policies, and I want you guys to think about this. I don't want your policy and your handbook to turn out to be evidence used against you. And so, you know, I always ask that question, and it's a topic that we use in some of our talks, is your handbook helping you, or is it actually evidence? And the truth of the matter is that if you get in a lawsuit, your handbook really can protect you. Your employees are protected by all the laws that are available to them. All they have to do is wake up and get out of bed. They don't have to put a handbook together. You, on the other hand, are not protected by all the laws available to you. And the only way to access many of the safe harbors is to create a handbook that is legitimate and it is compliant, and to distribute it to your employees and have them acknowledge that they've received it. Four typical areas where we see problems: travel and seminar pay, overtime not being calculated, recording time and the records that you're keeping around that, and misclassifying employees as exempt and not paying them overtime. I'm going to take this screen backwards, and I want to remind everyone that you're not just limited to the time that you're going to be here with me. Because of Procore and the relationship that we've developed with them, if you have a question after this, you need to call us and just ask, or email it to us. You can use the info@cedarsolutions.com. You can pick up the phone and dial that number right there in front of you. I'm in Tucson, Arizona. If I'm in the office and I can take your call, I'll take it, and if I can't, I'll get back to you. And if you've got a sticky problem and you want to try and get it solved, we might even be able to help you out a little bit with one of our experts here. I'll probably trigger a few of you. One of the things I want you guys to know is that a hygienist with a 2-year degree cannot be classified as an exempt employee, meaning that their hours must be tracked and they must be paid overtime, and it doesn't matter how much money you pay them or if it's based on a commission. So very important for everyone to know that. And I also want you to know that your 4-year hygienist may not qualify for the exempt status either. There is a classification called professional, and we have found that during audits that this is not a slam dunk deal that the hygienists are going to be seen as being exempt from overtime. And so this will be an area where if you're doing that, you're not paying them by the hour, or you're not figuring overtime for them, you might want to get in touch with us and get some more guidance. I'm going to interrupt myself here for a second. I think we have a polling question about whether you have a handbook, whether you guys have an employee handbook or not. If you don't mind, I'd just like to know, the numbers of the participants, kind of know how many people we have. So if you have an employee handbook or not, please answer the poll for us. Next area is recording time and records, and so I'll go through this very quickly. You are required by law to record the time of your hourly employees. You can't just pay them a salary and leave it at that, or pay them a set salary and not worry about it. You still have to record their time, even if you're paying them a fixed amount to say work for between 36 and 40 hours. So make sure that you're recording their time and records, and you would understand that if you had misclassified a hygienist and were not recording her time, then you would also, not only would you be breaking one law, you'd be breaking two. Again, I discussed this. Overtime is not calculated properly. Overtime is going to apply in most instances to travel and seminar pay, and you got to take that into account. And a common mistake I find is that because we pay every 2 weeks, we don't Because we pay every 2 weeks, if you work 36 hours in 1 week and 44 hours in the next week, that's 80 hours and that's 40 hours a week, and so we don't owe you overtime. Overtime is computed by the week, 7 24-hour consecutive days, so you can't shift it over into the second half of the pay period. Very common mistake. I see it less, but I still see it often. And then finally, travel and seminar pay. One of the misnomers is that you can make up the rules around this. I think it was Fight Club that ends a famous quote with, "And you are not special." And so what I'm saying is, as employers, we are not special when it comes to this, and we have to follow the federal standards. And then if you're in some states like California, the standards are a little more strict. Here are the 4 things that must be true in order for a seminar to not be compensable. It must be voluntary. It must be outside of their normal work hours. They must not do any of the work that they normally do. And then finally, the seminar cannot benefit them by helping them to do their job better for you. It can't benefit them or the practice. So my question is why would you ever take someone to this? So what most people think is they can have a policy that it puts it at the discretion of the doctor, or it says something like, all of our seminars are voluntary, or tries to qualify out the need to track these hours and pay them. And basically, none of that stuff is true. You can't use any of it, and you'll lose instantly in a Department of Labor audit on this issue. Travel time is a different matter. It does vary a little, but overall, you still have to pay for travel time if the travel time cuts across their normal work hours. And so their normal work hours are the time that they work, not the days. So if an employee only worked 1 day a week from 9 to 5, and you put them as a passenger in a plane, train, or a bus between the hours of 9 and 5 to travel to a seminar, that employee would have to be paid regardless of the day that the travel occurred on. Again, I'd be happy to help you guys gain more understanding around it, but if this is in your handbook and it's not written the way that I described it, then there's a strong chance that you're giving them sort of evidence to work against you. I know in the poll we were asking if you had created your own handbook. I want you all to know that I evaluate handbooks all the time, and I think that the lawyers say the worst lawyer the worst client to have as a lawyer is yourself. We'll address a little bit about these self-created handbooks. Corrective action policies. Give me a second, everybody. I'll take a little sip of water.
Hey, and also, Paul, just for your information
Sure.
on that poll, it looked like close to 70% of people had said that they created their own handbook.
Got it. That's a pretty high number. Mostly what people do is they borrow one from someone else, or they'll download something off the internet. There's places you can Google and get one. They'll go on to something like Dental Town, or they'll maybe even go to the American Dental Association and download theirs. And the problem with that is that if you're looking at a handbook, it's kind of like buying a car for your 17-year-old, and you're standing there at the used car lot, and you're thinking, do I get her the Volvo that has airbags everywhere? I mean, this thing is probably going to survive just about any kind of accident, whether it's their fault or not. Or do I get her the lesser car that's about the same price, but it looks cool, but it's all, it only has one airbag and it doesn't have any of these other protections. I think when you get out there and you start borrowing handbooks and relying on other people's work, you run the risk of, it's kind of like borrowing someone else's toothbrush. You don't really know where it's been. You don't know what problem it's carrying. And I know that, I've been to, good Lord, I've done continuing education courses. I've been in so many dental courses. I've learned about oral sedation, and I've sat in the back of the classes, and over and over and over again. I have some general understanding, but the last thing you would want me to do is knock you out and start doing dentistry on you. So I generally tell folks out there doing your own handbooks can really be a problem. And corrective action policies are a great example. A corrective action policy is an opportunity for you to document a problem and an issue with an employee, and really to do it in a way that you know, you're telling them what the issue is, you're letting them know what the impact is, you might be discussing, you know, things that you've done with them in the past to address this issue, and you're asking them to self-correct. So, you know, you're late, you've only been here for about a month and a half, you know that we specifically hired you to be here as the lead receptionist, as the lead person to answer the phone and run the front desk. The problem is that you continue to be 5, 10, 15 minutes late at least one day a week, and this week now it's been 2 days. When you're late, other people have to do your job for you. That means that they actually get behind in doing their job. It affects when we see patients. It makes it really difficult for us to know what's going on with our hygiene schedule for that day, because part of your first thing that you know you're supposed to do is to get the messages who's canceled appointments so that we can start to try to fill slots. And so when you're behind, it really does affect the entire practice. And so what I need you to know is that for the next 6 months, you've got to be here on time, Monday through Thursday. You know, you need to be here ready to go at 7:55 a.m., have everything ready, and have already started to take the messages and let us know how our day's going. Can you do that? And so you're communicating to them, and in some cases you're saying if you can't do it, then I need to let you know that we're going to let you go the next time you don't show up on time. If you even come in a minute late, I'm sorry. When you put that in writing and you have them acknowledge it, not agree to it, agreeing to corrective actions can create a contract between the two of you. When you have them acknowledge this, you are slamming the door on them being able to make up different arguments when you let someone go. And that is kind of your job now as an employer in a litigious society, is to be able to show that you had a policy, you communicated it, and you followed it to the best of your ability, and you let them know, and it works. It's terrible to the other side. It's very difficult to sue an employer who's been doing a good job at this. But policies that you don't want are 3-strike rules, which is if you're late 3 times, then we'll do something. We'll fire you. Or if you do this 3 times, we'll take the next step or put you in a special category we call the bad kid category. And then if-then scenarios. If you do this, then we're going to do that. And then if it happens again, we're going to do this. And then eventually we could fire you. You don't want to have those in place, because then you are obligated to follow them. So you want to communicate what your tools are. We have verbal, we have written warnings, we have final warnings, and we have termination. And we are not obligated to follow any particular progression, and we'll use the tool that is appropriate at the time. Very important that you have your corrective action policy notices written the proper way, so that you have the discretion to use them the way you want to use them. Your at-will statement. At-will means that you or the employee can end the relationship at any time for a reason or no reason at all, with or without notice. The caveat is that you can't let someone go for an illegal reason. An obvious one, you wouldn't walk in and say, look, I noticed you're pregnant, and I've decided to let you go. But if you were to fire a pregnant employee because she's had 4 patient complaints today, and you try to talk to her about it, and she told you to, jump out the window, and so you fired her out of anger, she would certainly make the case that you fired her because she's pregnant. And you would have a hard time, because pregnant employees are able to find representation quite easily. Now, I'm using that as an extreme example. So your at-will employment is not a bulletproof shield. It does not protect you from everything. However, at-will employment coupled with a good progressive correction policy where you have been notating issues with an employee and having them acknowledge your conversations is much more powerful, and it creates a complete story. So the other thing on at-will employment is we often see it improperly written. It's too broad, or it's missing some of the components about not forming a contract, and that the policies themselves don't form a contract. So you want to make sure that if you have it, it's written properly. And then the other thing is I hear it all, right to work. We're in a right to work state. Right to work is a union term. It means that in your state that the union still must protect the employee even though they can't require the employee to pay dues. So it has nothing to do with at will. So Again, if you've got something about right to work in your handbook, you probably want to get that out of there. You want to bookend your handbook with it and then refer to it in the proper areas. So if you have a 90-day introductory period, don't ever use the word probationary. If you have a 90-day introductory period, you disclaim it by saying during the period your status as an at-will employee does not change. And that means, hey, we could fire you right in the middle of your 90-day getting acquainted period if we want to, if we need to. You could quit. You could walk out on us, and it doesn't matter. And completing it doesn't change your status as an at-will employee. All important components for an employee handbook.
Paul, we have a question here before we move on to missing policies, going back to wage and hour violations.
Sure.
And somebody had a question about they were wondering what happens in the situation, or what you can do in the situation where you send somebody to get extended duties certificate or some type of extended certification, and you offer to pay for it as long as they remain an employee for a year, where essentially that if they left before that 1 year was up, then they would be required to reimburse you, the employer, for that education.
Okay.
Is that something that you can do, or how do you go about that?
We're not a big fan of that. That's called a golden handcuff. And it varies from state to state, because your recourse as the employer is what are you going to do if they quit or get fired? First of all, a big mistake is to say if you get fired or you quit, you have to pay that money back, and we're going to deduct it from your final paycheck. In some states, that deduction is just not even legal. In other states, it might be legal as long as it's agreed to in a separate agreement because it benefits the employee. So you could enforce it that way, but you would not want to put it inside of your employee handbook because it assaults the at-will status. Remember, you're saying that either of us, and it's mutual and it must remain mutual, either of us can end this relationship with or without notice for any reason without cause. The employee's argument is I did not follow your policy regarding sexual harassment and report it to my supervisor. I worked in the satellite office with the associate who happens to be the son-in-law of the owner. I knew that if I reported the sexual harassment, I would then get in trouble and I might lose my job. And on top of that, I would have to pay back $1,400 that I owed them because I went and took a course that they wanted me to take. I didn't want to take that course. They wanted me to take it. That would be the employee's story. And so with a golden handcuff policy in place, their attorney would argue against your first offense, which is they had an obligation to report this issue to me and give me an opportunity to address it. And that's strong. That's a very, very strong burden shifter. And so you wouldn't have that if they could make that argument. And even if they aren't great at it, if they can get it in front of a jury, it's a great argument. It's a good argument. So
and really, the impetus to this question in this particular situation is this dentist had sent somebody to some extensive training, and then right after completing the training, this person had quit.
Yeah. Yeah, look, on a case-by-case basis, this is not the worst thing that you can do. But as a general, everybody gets hit with it, and it's a policy and it's in place, it's not a great idea, and it may not be enforceable. So you would want to do it methodically, and knowing that if I'm going to put this in place, I actually could do something about it. And then, you know, in a lot of cases, you just end up you become a creditor. I mean, you would have to sue them to get that money back. And, you know, I don't know how much money you're going to get back out of a dental assistant, you know, on something.
So essentially, I guess what you're saying is then this should be a separate agreement, should not be part of your handbook. It's on a case-by-case basis, and your expectation isn't necessarily that if they quit, you ever get any money back, but you're putting it in place as a way to discourage them from leaving?
I think so. And again, you kind of wanted a little counsel on this, just from a good HR expert to say, you know, is this the right person to do this kind of agreement with? You know, obviously there was some problem there. I mean, that employee was, you know, I don't know, were they plotting this? You know, did they do this intentionally? And that's just, you know, it's just tough. Sometimes you just have to kind of, what we call an HR, it's a technical term, it's called suck it up, and you know, you just have to do it sometimes.
Thanks for letting me derail you here for a minute.
No, it's okay, man. So missing policies and protections, very important. I see these awesome policies that people have borrowed and traded with one another that discuss you know, your computer systems, and they talk about this stuff belongs to me and it's mine, and we have ownership of the content, and if it's a good policy, it says, you know, in our harassment policies, extend into this policy, and there's all kinds of stuff there. But what they fail to say is that while you're on our systems, you have no expectation of privacy, and you should go on to explain what that means. By having that statement in place, and you just got the power to do this about 2 years ago. We had a circuit court decision that granted this right to us as employers. What it means is that when you find something, whatever you find, even if it's in their personal email, if it's through your own systems that they were using it, you can then introduce it into unemployment hearings and into court. And so for us, when an embezzlement is occurring, and by the way, we're having a lot of reporting of embezzlement across all of our members. When embezzlement is reported, there's 3 key issues that we want to be able to do. We want to be able to track what it is they've been doing, and we do that through having good passwords and passcodes in place. So we know when they're coming in and out of the building, and we know who is on the software at the time that they are doing whatever it is that they do. Rob, I mean, you guys, are you hearing more about embezzlement? Are you being asked to look into this more lately?
You know, we spoke a little bit on embezzlement and how to put controls in place from an accounting perspective and who handles money to be able to mitigate it. And the statistics that I've seen related to embezzlement, and this actually is probably going to be shocking even to you, is that 75% of practices will experience some type of fraud annually. I'm not saying ever, I'm saying annually. Yeah. And that may be something as small as some type of fraud that's happening to them from a patient, from a billing perspective, or whatever it may be. But 75% of practices will experience some type of fraud annually. And where embezzlement is included within that, what percentage of that actually is embezzlement, I'm assuming is a small percentage. But there's things to do to protect yourself.
You know, Dr. Roger Abbott in Atlanta, they just made the national news, $2.3 million. She was very close to him, very trusted. I'm working with one of our clients right now. It started off as $16,000, would appear to be $16,000 in overpayments for payroll to that the clinic administrator was paying to themselves. It's now $80,000 as of yesterday that we've been able to ferret out. And it's important that everybody understand out there that this isn't just a matter of convenience. If you've got insurance in place, part of collecting that insurance is being able to file police reports. Part of sometimes getting the money back is being able to literally be able to threaten the employee, saying, I've got you dead to rights, showing them you've got them dead to rights, and tell them to go out and start borrowing money from their family to pay it back. You know, it's powerful to have the right policies in place. Another place that we want to talk about is shifting the burden of reporting issues. I talked about that earlier. You need policies, open door policies. You need policies around safety issues. And then an alternative dispute resolution procedure, which is an agreement. Again, it's shifting the burden, saying before you can sue me, before you can file a complaint, you have to have reported the issue to me and given me an opportunity to address it. And these burden shifters run throughout your handbook. There's about 35 opportunities from reporting problems with your paycheck all the way through all of the different sexual harassments. And there's 5 different harassments. All of those being in place are very helpful. Another missing key component, especially in self-made handbooks, is the non-retaliation clause. I'll put it plain and simple. almost all EEOC complaints are going to really not be that big of a burden to you when it comes to the monetary award to the employee. But if the retaliation part of it goes through, that's where the huge money is, and it is awarded through a jury, and it's what all attorneys tack on to all EEOC complaints. So there could be a $12,000 fine, but a $250,000 award for retaliating against the employee. For the reason you want the policy is you want to shift the burden over to their side so that they must prove it, as opposed to you having to defend yourself that you in the first place. So it puts a lot more work on them. And then, you know, I said this before, staying up to date and in compliance is not easy. I don't think it's a do-it-yourself game anymore. You know, I'm an HR nerd. I have 3 full-time attorneys, and I have a master's level, nationally certified, used to be the president of our local 1 million metro area HR society on staff. And I tell you guys, sometimes it's all we can do to keep up with some of the changes that are happening out there. So I don't know how in the world you guys would know. So super important that you stay up to date in compliance. You know, each year I evaluate hundreds of handbooks. This year we'll set a record. I think we're going to evaluate. We're on track to evaluate more than 700 handbooks. It's a unique service that we offer, which is to say, here's a way for you to kind of figure out where you are and to have a very related conversation about something that's incredibly important in your business life, because it can protect you. And well written, it can also make your office run pretty darn smooth. And as you can see on here, 93% of handbooks just out and out fail because they'll have something in there that could get you in trouble. So I know that 70% of the people on this call made their own handbooks. I would be stunned if any of them would pass. And so let's just talk about that a little bit. If you'd like to double check your handbook, because you've been on here with and you've come to us through Procore, we're going to extend what I think you guys will take, what I hope you'll take advantage of. I'd like to evaluate your handbook for you. So what you'll do is you'll send the handbook to us. We'll evaluate it on our time. We'll get back with you through email and put a call in real quick. We'll set an appointment, and I'll spend a half hour with you, and I'll go through your handbook, and where there's serious issues, I'll go ahead and let you know so you know what to look out for. One of the things that you do when you have bad policies is you have to replace them. You can do that. You can change agreements that you accidentally put in place. You can do all sorts of things through policies, but you have to kind of act and take care of it. So it's very, very important that that you do it in the right way, and you do it proactively if you think you have a problem. So one of the things not included on this slide is that you can send an email to eval@cedarsolutions.com. And many of you are very computer savvy. You could just go ahead and connect your, attach your handbook to the email. Send it in, put Procore in the title so we know where it's coming from. Include your name, the state. It's important that I know the number of employees you have, because different laws don't apply to smaller employers. And then a best number for us to reach you when we're done. General time, 2 weeks. We'll return it. We typically charge $299 to do this, because between the eval and the time with you, we'll spend about an hour and a half on the handbook. We'll waive that fee for you if you put Procore in the subject line. And I want to assure you, we will tell you what's available and what we do. We're not going to. This isn't a sales call that you're making to us. It's a real call through a professional association with Procore. And we'll be happy to answer your questions, and we do our very best to leave you guys whole. Rob, questions? Any closing thoughts?
You know, there's a lot of things that were new to me. After this, there's some things that I know that I need to change even within my handbook. So I really appreciate the education and the information. Being proactive in this area, I can see it does the same thing that we teach our people, being proactive with your financial information as well as your tax. By doing that, then you're able to mitigate issues as well as ultimately put yourself in a better position legally as well as financially. So I really appreciate the offer that you extended to be able to review people's handbooks. And so I would encourage anybody who's on here to take Paul up on that offer and then have your handbook looked at so you know where you're at, and I'm sure that he'll give you some suggestions as well. If you want to learn more about being a customer or a client of Paul's, feel free to contact him as well. And likewise, if you're not currently a client of Procore and you want to find out more about what Procore can do for you to be able to minimize your tax and help you to gain or get to what your practice can actually be. Our average client, we literally put tens of thousands of dollars more in their pocket every year by means of saving money in tax and increasing profitability. Feel free to contact me, or if you have Curtis's information, contact him. My information is up here for you to take a look at. Any last thoughts from you, Paul, before we get wrapped up?
I just want people to know that I know that we recorded this and that they may be listening to it in playback, and they may not hear this for a year. May not get to it until a year from now. It doesn't matter if you're hearing this, and to my members and my clients that are out there, we'll be making this available to you as well. If you hear this and you want to get in touch with Rob, please do. We'd encourage you to give him a call. And on your side, Rob, for your folks that are hearing it, it doesn't matter. Follow the directions, put Procore in the subject line, and send it to us, and we'll be happy to let you know where you stand.
Sounds great. Thanks, Paul.
Thank you.
And yeah, thank you. And everybody who's on here, watch for our future webinars. And again, as I mentioned at the front end, thank you for your feedback. And if there's any additional topics that you're interested in learning about or knowing more about, our objective really is to bring you good information to help put you in the best possible financial position. So thanks again to everybody, and hope you have a great day.